Hi everyone, good evening. I'm Advocate Aishwarya Sandeep, and today we'll be beginning with the third module. Just give me a couple of minutes, I'll just share my screen with you. While talking about the third module, which is the main legal drafting that we would be covering. We'll be talking about different types of agreements like sale and lease deed agreement, loan agreement, leave and license agreement, employment, non-disclosure, share purchase agreement, your mortgage deed, power of attorney, uh, post-contractual agreement, cloud computing, software development, manufacturing and supply, termination agreement, IP, uh, master agreement, and your IP master. Okay, so basically, the whole idea behind having an agreement is that we put all the crucial points in writing so that no one can steal it from you, nobody can go back on whatever they have committed or whatever they have agreed to deliver. While talking about, let's talk about sale agreement that we are going to have. So when are you going to enter into sale agreement? Sale agreement is generally entered into when you want to sell a property. Now, which property can I sell? When I am talking about sale agreement, I can sell a property only which is in my name. I cannot sell something which is not owned by me. Sale agreement may seem to be a very simple document that एक draft बना दिया हो गया, but it's not as simple as that. When you talk about sale agreement, there are a lot of other factors, there are a lot of other concepts uh, which may seem to be very collateral, but will uh, be there. So let's talk about the laws which are applicable in the first place. Your Transfer of Property Act has mentioned non-movable property and movable property. When I am having a sale of a movable property, so okay, we'll just go a step behind. I'm sure everybody might know now knows what is the difference between a movable property and a non-movable property. So movable property is something which is not attached to the ground. Anything and everything that is attached to the ground is a permanent fixture, is something uh, that is like a grass or a crop, that is your non-movable property because it is attached to the land. When you talk about attachment of a property to the ground which is not attached, sorry, any property which is not attached to the ground, that is what we call as non-movable property. Now if I'm talking about non-movable property or movable property, if you want to sell it, you need to have an agreement. Second thing, whenever you are entering into a sale deal, there are three magic words that I would like to call. So these three magic words are right, title, and interest. Now, when I am selling a property, I am not just selling uh, mere physical possession. Okay, I am also simultaneously selling my any extended right to the property. That is my right to enter into the property at any given point of time, my right to enjoy the property or exploit the property. I cannot grow any vegetables, or I cannot access the party. And right, so that is your right. Any legal right with respect to the property, you have to give it up. Right, and then second thing is title. Okay, you are also transferring the title of the property. That is, tomorrow once I sell the property, the title, that is the name of the property, will change. Now, title of the property is not limited to just having a sale deed or a sale agreement. It should also be reported in the other documents or your land records. For example, if I'm buying an open property, okay, in Maharashtra, there is a document called as property card, which is there uh, with your collector's office, or it is generally called as Satbara or 7 by 12 in Maharashtra. Property laws, property registration laws generally change from every state to state. But the basic principle of using the law remains the same. After your right is transferred, your title is transferred. Transferring of title means the name on the society notice board will change. Your name on the electricity bill, your water bill, property tax, maintenance bill, everything will be in the name of the new seller, the new purchaser. After that, the next thing is your interest. Tomorrow, if I have sold a property, that doesn't mean that I can go and tell my relatives that I am the owner of the property, or I cannot go and sell I cannot go and give the property on rent to anyone, or I am not allowed to live there. So I should not have any interest. I cannot mortgage or take a loan in the name of this particular property, which I have just sold. So, three magic words that you will use during the sale of property is sale of right, title, and interest. Until and unless you don't transfer the right, title, and interest of a property, you cannot have a good property. Okay, you are not entering into a legal sale deal. So the document that you are going to execute for the purpose of a sale property is called as a sale deed. What exactly is the difference between an agreement and a deed? Technically, it is just nomenclature, but any deed has to be registered, and agreements are not required to register, not required to be registered. Your deeds are documents which bring a huge change. For a change, for example, an agreement between an employer and an employee is just a personal concern. It is not the concern of the society. It is not the concern of the society at large. So therefore, you don't need to register it. It's a mutual transaction between two individuals. Similarly, for any business agreements that you have, but a sale deed, a leave and license agreement, or a lease deed, they have to be registered. Anything with respect to the right, title, and interest of properties need to be registered. So let's go ahead further. So this is a rough draft, a generic draft that I have made, that is drafted for a lease deed to be entered in the state of Maharashtra. Now, this has the principles. We have used the principles of Transfer of Property Act, as well as the which other act will you use for sale of property? The laws that are applicable for the sale of property are your Stamp Duty Acts, your Ready Reckoners, and Registration Act, to know how much percentage of registration charges you need to share, etc. Okay, so because you have to, what do you say, sell the property, you need to, because you are selling the property, you have to also find out the stamp duty. Now, stamp duty is exactly the amount of tax that you are going to say. Sorry, the tax that you are going to pay, because I am transferring a property from, I'm giving it to my friend, or somebody is paying money for the sale. So therefore, there is a stamp duty. You will get the amount of stamp duty to be paid with respect to the said transaction in your state stamp duty act. For example, in Maharashtra, we have Maharashtra Stamp Duty Act, under which you will get what is the amount of stamp duty that I will have to pay. Second thing, once a sale deed is, signed into, it is mandatory to get it registered. Now, one problem I have seen with a lot of individuals, and it's very sad, when you see it in reality. Uh, this happens a lot with these proof builders. People just pay a huge amount of money to a builder saying that I'm purchasing XYZ flat. For this, advance payment is so much. There will be some X amount which will always be paid in cash. And then you don't have any record for the sale. Then they enter into a sale agreement. Now, this sale agreement for the same, sale of flat, this builder must have entered into 10 different agreements. If this agreement was registered, we could have found out that, this is a fraud. You cannot register a sale deed for one particular, location 10 times. Only one time, one property can be sold. So it is important to understand that before you even start drafting, there are some basic laws, there are some basic history of a particular transaction that you need to enter into. Now, your sale agreements are one of the agreements which are drafted in depth. The reason being, you have to also register the history of the document, the history of the property. How far are you going to write the history of the property? Around 30 to 60 years. Now, there is a reason why we have huge recitals. Okay. So we'll come down to the recitals clause. Before that, we'll just begin with our basics. This is the title of the document. What is the nature of the document? You are selling your property. Therefore, it is called the sale deed. It is entered into between who are the two individuals. One is Shree Corporation, which is, let's assume, the builder or the seller. Now, Shree Corporations is a partnership firm. Partnership firm, just like a company, is an artificial person. It is not a real person. So when an artificial person sells a property, then you have to sell it to a human partner. And this human partner is what we call as, a person who has got the authority. So you will say it is by its authorized partner, Mr. So and so. You will add the PAN number, which will show the identity of the person, and they are called as the seller. Okay. So this is how you are going to write if you are writing about the partner. Then comes Mr. Rajesh Patel, who is the purchaser. He is an individual, so only his details will be mentioned. Okay. This document is this section or this part is usually known as the recital. And when you talk about recitals, in case of a what do you say, property document, this clause is huge. Okay, this clause is usually, it talks about the history from where from where the property came into existence, how it was divided, if it was a part of a larger part of that property, how it was sold, who purchased it, then from whom it was sold. So in Bombay, at least, there is a practice of using minimum 60 years history or minimum 30 years history. The reason is simple, because we had the Bombay Tenancy Act, okay, until some time ago, under which there was a rule that you have to show the history of 30 years or so 30 years, anyone who has been in the possession of the property for 30 years or more, or has been residing there and enjoying the benefits of the property, then he automatically becomes the owner. So, in order to understand that where did the property come from, since how long has any individual been enjoying the property, you need to mention how you need to mention the entire history since 30 years. Even now, recently, the Supreme Court has put in its court orders that you need to mention 30 years history in the property, okay, in the agreements. Now, as I said, these are the golden words: right, title, and authority. In some places they use right, title, and authority, or we can say the seller has complete right, title, and interest to sell, transfer, and convey the said property. Now, you also need to mention that there is no litigation, there is no pending charges, it is not mortgaged, etc. Okay, that is very important to be mentioned, because, as I said, you cannot sell something that does not belong to you. Now, if there are any pending charges, there is litigation, or if there is, you know, litigation, or the property is disputed, there is a fight going on between two brothers with respect to ownership of the property. In that case, neither of the people, neither of the owners, they can sell the property. You must have seen this board at a lot of places that this particular property is disputed and the ownership of this property belongs to Mr. or Miss XYZ. Okay, so moving further, to your next clause, that is your main body clause. You will mention the details of the property. Now, in your whereas section, that is in your recitals, you have given the discrimination of the property. Then you will talk about what exactly are your terms and conditions. Under what circumstances or under what conditions are you, uh, selling the property? So you're selling it to the purchaser for 1 crore rupees, and he's selling, also transferring his right, title, and interest absolutely and forever. Okay, he's not going to do it for a certain duration of time, he is doing it forever. Then comes the possession. Now, here the seller is saying that he is going to give the possession of the property as and how he wants to, in an as is condition. In case if there is attachment, any furniture that is there, if there is any, anything that's left, or you want to give any additional attachment like a garden, a club membership, or whatever is the additional thing that you're giving along with the property, you will mention it. Okay, now moving further comes the title and encumbrances. So what exactly is the title of the place? Who owns the place? Here you are saying that the seller is the lawful owner of the property, and he is free from all encumbrances. That is again that the property is not under any lien, it is not mortgaged, it is not uh, you know uh, kept for against a bank loan or anything as such. Then comes the taxes and expenses. Now we also have another clause with respect to your payment and conclusion. That is the indemnity clause. Now, why do we have the indemnity clause? Sometimes it happens that you give a certain representation to the client, and because of that, the client purchases. So, therefore, whenever we sell a property, we say that the property is sold on an as is basis. So when I say that it is being sold on an as-is basis, that is ASS as gap is basis, as is when is. That means that today, if the paints of my house are chipping, there are 5 chairs and 5 tables and 5 beds in the house. The purchaser has seen is I am selling my property in that condition itself. I am not going to add any POP. I'm not going to add any furniture. I may not even remove those five, beds and chairs, etc. Then comes the indemnity. So indemnity states that the seller shall indemnify and keep indemnified the purchaser against any future claim. That is, as I said, sometimes it happens that there is a partition deed that is still going on. There are two brothers who have a fight. They are waiting for the property to be divided, but still one of them decides to go ahead and sell the property. Now the person who sells this property, he doesn't have the authority to do it. Okay, so when you don't have the authority to do it and you still go ahead, many people, they are also aware that there is no proper authority or any details that have been shared. So there is no partition of, say, property that has happened. There is no procedure that is followed. But even despite that, one of the parties goes ahead and enters into a sale deed. In that case, the person who is entering, the brother who is entering into the sale deed, he agrees to indemnify. One problem. So one of the major problems is that that you know the seller says that the purchaser, he can enjoy the property in a peaceful possession. There are no other rights. That is, the said property is not under any other disputes. You don't have any other obligations or anything that is pending. Okay, you will attach the schedule of the property. Now, when I am talking about the schedule of the property, it means how and where exactly is the property located. What is there to the left, to the right, to up, down, etc. of the said property. Why is it important? It's important to identify your land taxes are going to be based on the location of the property, and therefore the schedule of the property is important. Now this is how you are going to mention that all of the piece at parcel of the land at measuring. Now this was the sale deed for a land that was located in Mumbai. I'll give you the property detail is so and so, and it is situated at Marway Road, bearing blah 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 blah, and you will give the other details. Okay, you will have the signatures of both the parties. You will have the what do you say? You will have the relevant documents, that is PAN card of both the parties will be required. You may also require the Aadhaar card, 3 photographs. These are all basic history. Okay. Now there is one procedure that as lawyers we follow, especially when there is a high net worth of transaction, or when you are purchasing open land. This process is called as title search. That is, you are searching for the title, whether this person actually holds the property in his name or not, or he is just claiming. So even though you have your own seller, you will still go ahead and do your title search. Where will you do your title search? You will search for title in the office of the sub registrar. So generally we don't do it individually. We used to have clerks who used to do title search for us. So while you're doing title search, one thing you need to remember is, again, title search has to be done for a time period of either 30 or 50 years. If the property, so you need to mention all these details, that which title you're using, sorry, which property you are registering, and you have to get a history of minimum 30 years. Like if the building is 40 years old, then a property or property history or a title search of 30 years. Or if it's an open property, in that case you have to do a title search for almost 60 years. Now, these are certain practices that certain individual lawyers have. This is the practice that we used to do, and this is the norm that was followed by us. It depends again from every lawyer to lawyer, but because I've personally experienced this, it's something that I would recommend. Okay. Then comes your, what do you say? Your lease agreement. Okay, your lease agreement is something that is created to give a property on rent, kind of a rental property, but for a longer duration. Now when you talk about lease of a shop, so in Bombay, ideally the norm or the practices, when you are giving a commercial property on rent, you can give it for a minimum duration of 3 years. Wherein for a flat, you have to give for a minimum, if you want to register a document, lease agreement, you need to give it minimum for a period of, when you're giving, for give it for a period of minimum of 3 months. Okay, sorry, 3 years. That is what I said. Again, your lease deed has to be registered. So I've been talking about registration of documents, how it is mandatory, it is important. Let's talk about where are you going to these any property related documents. Any property related documents is usually registered with the office of the sub-divisional registrar. Any property related disputes or any property related documents, you will file the complaint, and you will also do your registration, title search, everything at the office of sub-registrar. Okay, so you have to find out in which jurisdiction your office of the sorry, in which jurisdiction your property is located, and you have to uh, do your registration in that area. Okay, in that office of sub registrar. Moving further, so this is the rough deed that we have. So then we'll just go ahead and proceed with the lease. So your lease deed is basically a rent agreement, or when you're giving something on rent, you're not transferring the right, title and interest. In the difference between a sale deed and a lease deed is that in a lease deed, you are just transferring the physical ownership or physical right. You are not transferring the right title of or interest. The right title or interest still belongs to you. So this is again a draft of lease deed which is made between one Sri Corporation and one Mr. Rajesh Patel. Okay, so you will mention who is the owner, what are the details, etc. This is the recital. Again, in a lease deed, your recital need not be in much detail. So basically, the whole purpose of having a recital clause is that you will mention the purpose of having an agreement. Why exactly have you entered into an agreement? What is the purpose of your agreement? Why are you, what are the basic conditions? As I said, on an assess basis, how you are entering into an agreement. Okay, so that is the basic detail that you are going to add. uh, Again, compared to sale deed, now when I'm teaching you about lease agreement, I will be having a comparison with your sale deed. Okay, so that the difference is clear and it is easier for you to understand. Now, here you have given the details, that is what exactly is the property that you are giving on rent. Okay, so here there is a transfer of rights also. You're giving, that is your physical possession, then you're giving easement rights. I can use the property, I can use the other details, etc. And the appurtenances attached there. That means if there are any fans, tubes, any interior work is done, etc. etc. Then comes the term, the duration at which you are going to share the lease agreement. You will insert whatever is the starting date, you will insert whatever is the ending date. Now, this can be executed at for how much ever duration you want, and it will be renewed mutually. Now, one person individually cannot renew the lease. Okay, you will mention whatever is the rent. So you will say that a rent of X amount of rupees will be payable on the fifth day of every month. Now, with respect to term of deposit, okay. Now there is a huge debate in different states. Now there is a huge debate in different states that when you are having a deposit, how many months of deposit are you allowed to charge? The usual trend of charging deposit is that one, in case if the tenant does not pay rent. Okay, so then you need to have some advance money in your hand for as a safety. That is the whole idea of having a refundable deposit. Or in case if the tenant causes some damages, there is some problem to the walls, etc. So you need to address the said issue. You need money for the sale, and therefore a security deposit is deposited while paying. Now, what I have heard is in Bombay, generally the idea is 3 months ka rent. But in cities like Bangalore and all, I've heard they take around 10 months of deposit, which is absolutely wrong. Okay, you cannot take deposit up to 10 months. And I've seen that. I just read a case today morning. It happened in Bangalore, wherein a couple had rented a commercial premise they didn't enter into a proper, what do you say, proper lease agreement. Rather, there was no lease agreement at all. Everything was done using a standard agreement. And they had that term had come to an end. They were paying all the monthly charges, and there was no, there was no uh, problem with those tenants. The only problem was they didn't enter into a proper watertight agreement. They had taken permission apparently from the owner of the property to carry out any structural changes in the property. That is, they wanted to do some interior. As I said, as it was a commercial property, so they wanted some permanent fixtures. So this couple, they do all the interior, etc. Now the property has been, the tenancy period is over, and they are trying to move out. The owner, he refuses to give the security deposit, saying that you have caused damage to the property. You were not supposed to drill the walls. You were not supposed to cause any structural changes. Your interior has done this, that, etc., etc. He's given an excuse, and he has retained the interior. Now the problem is the agreement is a standard agreement. It is very vague on this aspect, that who will use the interior that is provided. So most of the times nowadays, what people do, especially those who stay on rent, they do not invest in the furniture. They only get it on rent, which can be returned back whenever they are quitting or whenever they are going on rent. Then comes your this thing. Then is your term, your interest on the deposit. Now there is no concept of interest on deposit or anything. If X amount was given as a deposit amount, the same X amount will be given back to the tenant. Okay. Now let's talk about use of premises. Now the lessee will use the said premises for the purpose, whatever is the purpose that you're using. If it's for a restaurant, you're using it for office, storage, whatever it is, you are going to mention. And except that, you cannot use it for any other purpose. Carrying out any other activity without the permission is illegal, hazardous, and causes nuisance to the neighboring premises. You cannot carry out any such activities. Okay. Then comes the maintenance and uh, maintenance clause. So here it is mentioned that again the term as is used over here to ensure that the tenant also knows, it was on record, what exactly as is means. Now, if you are giving an interior of, there are going to be 3 cold storages, there are going to be 6 fans, there are going to be 6 coolers, there are chairs and tables, etc. If all this is also rented, you will mention the same. The whole idea behind having the maintenance and repairs clauses, so that the uh, person who is renting also knows that what is allowed and what is not allowed. One mistake that a lot of people who rent properties do is they themselves voluntarily carry out structural changes without any written permission of the owner, and then that is called as and then after that uh, your lease, sorry, they carry out it voluntarily as per their use, and they are more or less permanent fixtures. Now these permanent fixtures, they cannot be removed. Okay. If you cannot remove the permanent fixtures, in that case it will cause the damage to the property, and the owner himself will not be able to give his house to any other uh, tenant. For example, if it's a setup for a restaurant and there are some permanent fixtures which was given by the builder, in that case it's okay. But if you as a tenant are creating some sort of fancy arc, you're creating some sort of whatever it is, any fancy designs, in that case you cannot expect how the landlord to compensate you for the same. Okay, moving further, moving further, all the maintenance and repairs have to be actually carried out by the owner. If at all there are chances that you have to carry out any maintenance and repairs, you will carry and show you. It has to be like you can carry out, and then you have to be compensated for the same by the owner. Again, alterations, the general practices, there are no alterations that can be made by the person who is staying over there. All the alterations have to be carried out only with the permission of the, whoever is the owner. Now, the lessee, they will not assign or sublet or part with the possession of the premises or any part thereof without prior written consent of the lessor. If you want to sublet or part with the possession, then again it will invite charges and a case of breach of contract can be registered against you. Then comes your termination clause. How can you terminate the agreement? What are the cases of termination? How to figure out how to terminate? You have not given rent for 3 months. If you have not kept the property properly, all these things will help. Okay. Now moving further, your termination details and all will be said, that how security deposit will be given, how rent will be given, rent will be reduced, etc. Now here the term for default is 2 months. Generally we give a term for 3 months, but in this case it is 2 months. Indemnity, here they are saying that in case of any claim, damage, loss or liability arising due to lessee's use or misuse of the premises, then in that case he will indemnify. Now, why do you need to have indemnification in a rental agreement? Is because many a times, like at least in Mumbai, I've seen cases wherein the people who were living on rent, they mortgage the flat that they were living, and not mortgage the flat, they give the address for communication of that particular flat as their permanent address or something like that, and then they took a loan. Okay, they took personal loan, credit card loan, all these loans, and then they would vanish away. After that, it would be the house owners who would then be chased by the police. This had actually happened with my parents only, what I'm telling you. So yeah, so it was very difficult to handle that. Our tenants had taken a loan and they had not paid a few installments. Uh, Somehow they had given my brother's address for contact, etc. And we had not signed any documents. So then ultimately my brother spoke to the bank after a long chase. He was luckily there at home that day, and then he spoke to the bank authorities and said that they were tenants, but we are not aware about any such transaction. So for this particular purpose, it is very important to have indemnity clause. Then comes your governing law and jurisdiction. So what exactly are the laws that you are going to govern? You're going to use your local laws, the state in which the property is located. You cannot use a random law. Okay, when you talk about governing law for the sale or for even license of a property, it has to be the law that is the law of land where the property is situated. Okay. Again, the schedule of the property, very important clause. and you will mention the signatories and witnesses. Registration, if the duration is less than 11 months, registration is not required. Duration is 11 months or more, you need to pay stamp duty registration charges according to your local stamp duty act, and you have to uh, register. Okay, the registration charges in this case is borne by the landlord. In case of a sale deed, again it is borne by the purchaser. Okay, then comes your loan agreement. Now this is a simple draft of a loan agreement wherein there is a case of an employee taking a loan from your employer. Most of the times, some people prefer to take loan from their employers because it is one easier. Second, the interest rate applied is very less, as employers are not banks, but they can give loans to some individual. Now, this loan agreement is a very tricky document. There are many cases wherein they have filed loan agreements. They have used loan agreements to siphon off funds from the company. Okay, common thing that happens in companies is one of the directors. Now, directors are also employees. One of the directors will take a loan from the company. We show it as a loan agreement. There will be a fake scenario wherein it will be shown that they have tried to contact him, but he has resigned and he is not paying back the loan. Or the loan will be in the name of some other shell company, or it will be in the name of his relatives, etc. And after that, they will siphon the money. 2 to 3 years down the line, they'll say it's a bad debt and strike it off. So the money is legally siphoned off from the company. Okay. So this is something that we had come across many such cases wherein uh, the employees and the directors, they had siphoned money, and then the same money was used to purchase the shares of the shell company, which again then purchased this company itself on full cash basis. Okay, so this is one thing you have to be very careful about, especially when you are doing legal due diligence. So loan agreements are a nightmare during your corporate due diligence, or when we do cases of mismanagement. So what happens in mismanagement is one management always blames the other management, saying he took off the money, there is siphoning, this, that, blah, blah, blah. That is the time when you will go and specifically ask, are there any loan agreements? Your loan agreement is going to be your starting point from where you can get actual proof of siphoning of funds. Even though there are various ways of siphoning of funds, the most easiest way to do it is through loan agreements. Okay. So you will state between whom the agreement is entered into, names of the parties, and how much loan he has asked for what purpose. You will say that the lender is going to give a loan of 3 crore rupees and it will be disbursed in a single installment to this bank account. It will carry an interest rate of whatever it is, whatever interest percentage, or it's an interest-free loan per annum, and it will be accumulated and payable along with each EMI. Now he agrees to repay the loan amount in whatever is the duty. You know, how many installments, how many, whatever are the details, you will share this with. Now repayment will be made via salary deduction, and the borrower will have an option of prepayment of loan in part or full without any prepayment penalty. You can pledge, you can assign any security, that depends on the terms of the loan. You will mention what is the purpose of the loan. Is it for purchase of property, medical emergency, family expenses, education, whatever is a legitimate purpose, personal purpose. Nothing for illegal purpose or for any wrong purposes, a loan is disbursed. What happens in case of termination? So, in case of termination of an employee, you will have to immediately pay the pending amount, okay, within whatever is your notice period, and you will say you have the right to recover the dues from any pending salary, gratuity or retirement benefits, and full and settlement, final settlement dues. What happens in case of default? Okay, if he forget, doesn't pay EMI or any money for due date, if he leaves the employment without informing or clearing dues, if there is any misrepresentation or breach of this agreement, what will happen? Then the lender, the company, they can accelerate the loan, they can demand full repayment, they can initiate whatever is the proceeding for recovery, initiate default to credit agencies if it is applicable. Then comes the indemnity standard clause, your dispute resolution, that laws of India will be applicable, and your miscellaneous clause. Okay. Then comes the signatures of both the parties. So this was in short with respect to three agreements that we did today. That is your leave and license agreement, your lease agreement, your sale deed, and your uh, loan agreement. We'll be continuing with our next agreements in the next session. Okay. So thank you so much and have a great day.